Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. On May 6, 2024, the Government of Canada tabled Bill C-70, an act respecting countering foreign interference, in the House of Commons. The bill does a number of things related to its title, countering foreign interference in Canadian society and Canadian politics. The bill will create a Foreign Influence Transparency and Accountability Act and makes a number of significant amendments to other statutes, such as the Criminal Code, the Canada Evidence Act, the Security of Information Act, and the Canadian Security Intelligence Service Act. Now, I regularly advise clients on how to respond to law enforcement and other demands for access to customer or user information. So a particular part of the bill caught my eye. Among the proposed amendments to the Canadian Security Intelligence Service Act is the creation of a new preservation order and a new production order for CSIS. I did a prior episode on CSIS Act warrants, which I'll link to below, and discussed how CSIS has been looking for a new production order power for a long time. Well, it's here. I am generally in favor of the new order. Absent a production order like this, CSIS is only able to compel the production of information via their search warrant powers under Section 21 of the CSIS Act. For third parties that may be in possession of information that's the subject of a court-approved warrant, the warrant is an awkward and sometimes unworkable device. The warrants are generally classified top secret and open-ended. They sometimes do not name the specific subject of the inquiry or an account identifier. Those may be discovered in the process of the investigation, are covered by the warrant, but are not written in the warrant per se. As a result, when CSIS is looking for information about customers or users of third-party services, they're not able to provide that service provider with a full copy of the warrant. This, of course, causes difficulties for those who need to satisfy themselves that the service has the lawful authority to acquire the information and that the service provider is lawfully permitted to disclose the information without a risk of liability under Canadian law. This problem should be solved with the new production order, since it will name the organization that's being ordered to produce the records, and it will name the specific records being sought. Thus, the organization on the receiving end of it will be able to satisfy themselves that it's a lawful order and that they are being required to produce specific records. The new production order for the CSIS Act largely mirrors general production orders under the Criminal Code. A CSIS officer will have to appear before a designated federal court judge and satisfy the judge, based on information under oath, that there are reasonable grounds to believe that the information, record, or document is in the person or entity's possession or control, and that it will assist the service to investigate within or outside Canada a threat to the security of Canada or to perform its duties and functions under Section 16. This is similar to a showing of probable cause in the U.S. The new CSIS Act provisions say that the order can apply to data and records that are outside of Canada. Notably, it's silent with respect to its application to organizations outside of Canada. Applying this extraterritorially will be problematic, and probably more problematic than attempting to do so with the Criminal Code production order. One can see that countries often have a common interest in investigating crime, but interests may diverge more vigorously when you're dealing with the covert collection of security intelligence information. Canada would understandably be very offended if the Chinese security service attempted to compel records from a Canada-based Canadian company, and the reverse is likely also the case. As with Criminal Code production orders, the organization that is on the receiving end is able to apply to have it varied or revoked. The grounds to vary or revoke such an order are in the new Section 20.5 sub 4, where it says it can be revoked if it is unreasonable in the circumstances to require the applicant to produce the information, record, or document, or the production of the information, record, or document would disclose information that is privileged or otherwise protected from disclosure by law. For U.S.-based organizations, it's arguably unreasonable in the circumstances to require the organization to violate U.S. law, such as the Stored Communications Act. It may also be argued that the data that is subject to a non-Canadian blocking statute may be otherwise protected from disclosure by law. The same may apply for European entities under the General Data Protection Regulation. Importantly, an application to vary or revoke can only be made within 14 days of receiving the order. It says at subsection 2, the person or entity may make the application only if they give notice of their intention to do so to a judge and to an employee in the Form 5 of Schedule 2 within 14 days after the day on which the order is served. Also, like the Criminal Code, the proposed amendments will give CSIS the ability to obtain a preservation order. Unlike a preservation order for law enforcement in the Criminal Code, Section 47.013, these orders are not restricted to computer data. The proposed CSIS Act preservation orders extend to, quote, any information, record, or document, regardless of the medium or form, or thing, These orders granted by a federal court judge can be made where there are reasonable grounds to suspect that there is, quote, any information, record, or document, regardless of the medium or form, or thing, that will assist CSIS in carrying out its mandate, and that CSIS intends to seek that data or thing via a warrant or a production order. Notably, things cannot be obtained via production order, just via a warrant. Overall, I see this as a positive development since these preservation orders and production orders are much more streamlined and easier to comply with. They are only available first with the approval of the Minister of Public Safety, and then only with judicial approval based on information under oath. I think the appropriate checks and balances are there. Although, one thing that I would like to see would be a clear limit on targeting so that these could not be used for fishing expeditions, like some of the tower dump cases we've seen with conventional criminal code production orders. I hope this has been interesting and useful. I try to put out a new video every few weeks or so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.